For more on the Sidney Powell plea agreement, let's bring in now CBS News election law contributor David Becker. David, this is a significant admission. Sidney Powell really was one of the loudest election deniers. And I'm just wondering if, because of that, are you surprised by this deal in which she admits that she breached voting equipment? Does that surprise you? Do the terms surprise you?
It doesn't really surprise me. I think Robert Costa laid it out exactly right. She was integral. She was in the Oval Office. She was taking part in all of the activities to subvert and overturn the will of the voters in 2020. She was standing at that famous RNC news conference with Rudy Giuliani, spreading lies about the outcome of that election. And she had requested a speedy trial in this case, one of only two defendants to do that in Fulton County, Kenneth Chesbrough bringing the other. And they were going to jury selection on Monday. And in doing so, she was probably gambling that the Fulton County DA wasn't going to be ready and have enough evidence to present. And that gamble appears not to have paid off. It appears the Fulton County DA was very ready to go forward, had won several motions recently in court with regard to evidence that was going to be presented at that case. And I think what happened is she blinked, and she made very clear she was willing to testify against her fellow co-conspirators, which is very important because the rest of the terms of this plea agreement seem fairly favorable to her. She doesn't have any jail time or prison time. She's pleading just to misdemeanor counts. She has a very minor fine. She has to write a letter of apology to Georgia citizens. But the biggest aspect of that is she has to testify truthfully in any future trials. And I think we're going to see how that plays out. But I suspect that the DA would not have made that deal unless that testimony was very compelling.
Right, because if you're watching this and you think to yourself, if anyone else breached an election system, would they have to pay a fine, serve probation, write a letter, and without testifying against her former client, former President Trump, which suggests to me that Donald Trump should be concerned, the co-defendants should be concerned, because her testimony will need to be meaty, for lack of a better term.
I think that's exactly right. She was charged with intentional interference with election officials' duties in Coffee County, Georgia. And it appears the evidence was going to be very serious in that case that was going to be brought against her in this speedy trial that she requested. And undoubtedly, when they were in negotiations with the DA's office over this plea, she would have to make some kind of what's called a proffer to indicate what kind of things she would testify to so that the DA could determine whether or not they would accept a plea agreement. They did so in this case. So I think it's fair to conclude that the DA was quite satisfied with what Sidney Powell, who was involved in Oval Office meetings, who was involved in meetings with other co-conspirators in this case in Georgia and perhaps elsewhere, that she's ready to testify about all of those things.
If her testimony turns out to be weak, though, might some of the status of the terms change?
I think it's very unlikely the status of the terms would change as long as she's testifying truthfully. We have to remember also there's a couple of things that she's not going to be able to rely upon here. With regard to the Georgia charges, she is no longer really in jeopardy there with regard to those charges. So she can't claim Fifth Amendment with regard to those charges. She might be able to claim that with regard to potentially other charges like federal cases. As Bob Costa mentioned, she's an unindicted co-conspirator in the D.C. case brought by Jack Smith against Donald Trump for election interference. She's also kind of tried to play it both ways with regard to attorney-client privilege. On the one hand, she said, I didn't represent Donald Trump. I wasn't his lawyer. But then she tried to claim attorney-client privilege. You can't do that. You only have attorney-client privilege if you're actually representing a client. And in this case, the court has already ruled that any privilege that could be asserted would be pierced by what's called the crime fraud exception, which means that it appears that those communications were about committing a crime. And in those cases, you'll have to testify.
A really incredible development. David Becker, thank you very much for walking us through what this means.
Thank you.